My lords.
Of this matter, because we are pained by the observations which were made by the single judge, of the High Court of Punjab and Haryana, while proceeding in the exercise of the contempt jurisdiction. The observations made in regard to an order passed by the Supreme Court.
This one.
And of course, there is also now a video clip which has been circulating, but the order is a part of the public record of the High Court.
Regarding video clip, I have some facts which I have gathered from members of the bar, my lord, from there, who are connected with the case, my lord.
Yes.
And there is something more, when your lordship permits, my lord, I may present it for your lordship's
The learned attorney general is also, I think he has joined online, but
he has joined.
The learned attorney is traveling today.
He is not in there.
I'm here before your lordship, sir. I took leave from the High Court, was appearing to present myself before your lordships, and I have read the entire proceedings. I think this matter deserves an intervention by the Supreme Court. There are many dimensions to what the learned judge should not have done, and while preserving the importance of the High Court, not as a subordinate institution to the Supreme Court, but at the same time, I think there is some transgression which is unwarranted. I think the court may have take a serious note of that.
Lord, so far as the video is concerned, Lord, I would request your lordships to see it in a particular factual context, which, my lord, in my submission, makes out a case for an aggravated contempt. My lord, I'll just give the background which are necessary, my lord, background facts necessary for the present purpose.
Yes.
Lord, this is post the judgment which your lordships have. Lord, what happened was there was a dispute between A and B regarding a plot of land with which we are not concerned, and a contempt petition was filed which came before the learned single judge. There, my lord, the contempt jurisdiction is before the learned single judge. The learned single judge exercising contempt jurisdiction could have either convicted or not convicted. But the learned single judge decided to say that neither A nor B let the land be vested in the government. That led to filing of a contempt appeal before the division bench. The division bench, my lord, was confronted with a preliminary objection by the other side that section 19 of the Contempt of Courts Act appeal lies only when there is a conviction. This appeal is not maintainable, and the appellant was arguing that this direction that land be vested in the state government could have been issued only in exercise of the learned judge's power under Article 226, therefore appeal is maintainable. The division bench felt that all right, we'll decide the question of maintainability. In the meanwhile, we stay that part of the order whereby the land is vested in the government, and we request the learned judge to adjourn the contempt proceedings beyond the day which we have fixed. In that context, my lord, this order, my lord, I have given the facts, my lord, I have prepared a chronology of events from, my lord, members of the bar, my lord, and I believe this to be accurate. I'll not read, my lord, every part. Kindly come to page 2, column number 8. My lord, this is the order of the division bench. Your lordships have, my lord,
Yes.
page 2, column number 8. 28th July 24, order of the High Court. Contempt.
Just one thing.
Yes, my lord.
Are we required to go into the facts?
No, your lordships are not. I am going to say something else.
Just one. You're not required to go into the facts and what is the appeal pending.
I am not on that.
Only issue is when there is a stay order passed by the court, which directs the stay of the contempt proceeding, being the appellate court, the hierarchical system we have, not that the High Court is subordinate to in a way, but we have the appellate forum system. So that order has to be complied with.
Correct.
The last paragraph does say that, but unnecessary observations have been made with regard to so many things which are not germane to that.
No, give me 2 minutes, my lord. Lord, in the video, now what happens is, the learned judge does 5 things. First, he says this order of the division bench is rubbish. The order which I said, which, my lord, in my respectful submission, could not have said. Second, he says, I refuse to follow that order. That, my lord, aggravates. Third, my lord, he says that you do not know, I have already declared one Supreme Court judgment to be non-est, which is before your lordships, and I have also declared one another division bench judgment to be non-est. That is, my lord, in the video. That I have nullified the order of the division bench, some other order of the division bench. Then, my lord, the learned judge says that judges are required to be sent for judicial training in the video, and my lord, sometimes expressions speak louder than words, and we have seen, my lord, the video. So, my lord, your lordships would take a call whether, apart from, my lord, a very serious case of non-compliance with this order, whether, my lord,
As far as, I think I'll just take justice also. The video part we saw one part of it, maybe one word which you said initially was certainly mentioned. Other parts we did not, we're not aware of.
yes, well, kindly see that because video is in circulation, a common man is watching that video, and these are the 5 facts which I found to be not just judicial indiscipline or judicial impropriety, it is contemptuous. And therefore, for giving the background of understanding the video, I am giving these facts. No, not that we are concerned with the facts of that case.
Mr. Solicitor General, what subject to my colleagues have to say, what we may do is that we are also informed that the High Court, the division bench of the High Court presided over by the Chief Justice, has taken slow motor notice of the order which was passed by the learned single judge, and that order has been stayed by the division bench. Notwithstanding the fact that that order has been stayed, we are of the view that we are not really about a particular judge or a particular order.
No, it's
But this tendency of making gratuitous observations on the work of the Supreme Court, because all high courts, all district courts work in a hierarchical judicial system. They've all been judges of the High Court, and that discipline has to be maintained. There is no occasion for a judge of the High Court. Judges are not agreed by any orders which are passed by a superior court.
Absolutely, absolutely.
They have to maintain the discipline of the discipline of the system.
correct.
And therefore, what we would propose to do is that we will expunge the remarks contained in the order of the judge, and expect, and as you have said, that the observations which have been made in the order are scandalous. They would have a bearing on the exercise of the contempt jurisdiction by this court. Equally, as courts at the apex of the system, we must also exercise our powers with great caution, because
That's right.
Because the remedy which we craft should not do greater damage to the judicial system. Well, we are conscious of the fact that though you have aberrations like the order which has been brought to our notice, the overwhelmingly large number of judges of the High Court exercise their judicial work with a great deal of responsibility,
Yes,
notwithstanding the
Doubtless.
overwhelming pressure of work which all High Court judges have to face. Therefore, we will not make any observations which will in any way affect the majesty of the High Courts as an institution. But surely, I think we have to exercise our jurisdiction and ensure that these observations should be expunged so that they do not remain.
Entirely your lordship's wisdom. Only, my lord, my concern was that the video is doing rounds. My lord, that also can be examined by the division bench.
Mr. I learned that Justice Rishikesh Roy wants to put some.
Yes, lord.
Solicitor, the 3 or 4 things that you have mentioned there, they are not part of the actual order that is recorded by the learned judge.
My lord, what
These
I,
are part of the proceedings, as you have mentioned in the video. So, in course of the proceedings, sometimes things are said and they are depicted and they are portrayed. But we are really concerned with what eventually is written down in the order of the learned judge. Now, obviously, as you have rightly pointed out, these orders could have been avoided, that kind of sentences, that kind of tone, tenor, even from there, as you said, the words spoken speak louder than words written. Well, perhaps you are right in that, but eventually, when we sit in the Supreme Court, we have to go by what is written down in the order. After all, the proceedings in the court are proceedings where we normally say that free flow of a change between the bar and the bench.
No, my lord, I bow down, my lord. It's your lordship's wisdom. I am not, my lord, for or against anything, but the video which is, my lord, viewed by everyone is post this judgment, where the learned judge says that you do not know. I have even nullified I have declared even Supreme Court judgment, that is this order, to be non-est, and one division bench order to be non-est, and all judge, my lord, it,
Now, that video which has been recorded is while hearing which proceeding actually?
hearing, my lord, proceedings where the division, as I pointed out, the division bench said that you have transferred the land to the government, which we stayed.
This was in response to the order of the division bench directing the adjournment of the proceedings.
Yes, my lord, that's what, my lord, the learned judge said.
Declared by the division bench.
It was
Yes, yes. So, there are two division bench judgments, my lord, the learned judge is referring to, that I have nullified them, and even Supreme Court I have said that it's a nullity, it's a non-est order.
Honest.
And say that all our, he is talking about the peer brother judges, that they need to be sent for judicial training, etc.
While
Presiding over the court, he is the master of that particular court.
Correct.
And he adjudicates the matter before him or her. And eventually, if you really look at it in a larger perspective, even the Supreme Court is not supreme, the High Court is not supreme, the Munsif is also not supreme. The supremacy is actually of the Constitution.
Absolutely.
We are all below the Constitution, and our task is to interpret the Constitution as we understand. And that is what the task.
And
of the court is.
144, that everyone should
And
work
coming
in aid
aid
of the Supreme Court of
Supreme Court orders, right? You are right there. 144 is a very glaring instance.
I only two reflections to share with the court.
Yes, Mr. Attorney.